Hello, and welcome to California Gun Law. I'm your host, Don Hammond. On this episode, I'm going to talk about the penalty for carrying a gun in a place that is prohibited by California's sensitive places law. This applies to people who have a California CCW license. Penal Code sections 26200 and 26230 do not have penalty provisions written into the statute, which makes them misdemeanors. I'll discuss how I came to that conclusion and what is really likely to happen if someone is caught carrying a gun where they're not supposed to. I'm a licensed California attorney and a shooting instructor. I regularly help teach the 16-hour class that is required to get a concealed carry license in California. On this program, we provide education on California's complicated web of gun laws so that responsible gun owners can better understand how to lawfully exercise their rights. California has a complicated web of firearm laws and regulations, and there are a lot of traps for the unwary. We want to help you do it right so you won't need our criminal defense legal services. Today, I'm going to discuss what happens if a CCW license holder is caught carrying a gun in a place that they're not supposed to. A lot of people in the online forums like to say, concealed is concealed. This is on places like Reddit, Quora, and Facebook groups. Shout out to the California Concealed Carry CCW, a great Facebook group that's full of helpful folks. Now, when people say concealed is concealed, I take that to mean that they intend to carry a gun wherever they want, regardless of California's sensitive places laws. So the question is, if they're caught, what's the penalty? Well, California's sensitive places law is found in Penal Code section 26230. Many parts of it are on hold in the courts, and I've made other videos about where you can and can't carry. So I'll very briefly list that information here. As of today, places where you cannot legally carry a gun, even with a California CCW license, include bars and restaurants that serve alcohol, playgrounds, parks, state parks, casinos, stadiums and arenas, libraries, museums and zoos, and any business with a sign that says firearms are prohibited. This is in addition to the standard places where you can't carry, including schools, courts, jails, local government buildings, polling places, and more. Now, the list of places where you can't carry changes with new laws and court decisions, so it's your responsibility to stay up to date. Okay, so what? If you're caught carrying a gun in violation of Penal Code section 26230, what happens? Let's use the most common example, a restaurant that serves alcohol. Think about a Chili's or Islands, or even that fancy steakhouse you like, maybe Mastro's. There are no other laws that prohibit you from carrying a gun there, as long as you're not planning to drink. But section 26230 says thou shalt not carry a gun there, even with a valid California CCW license. The problem is that section 26230 has no penalty provision. Most sections of the Penal Code say anyone who does X is guilty of a felony or is guilty of a misdemeanor, or they say anyone who does Y shall be punished by a fine not exceeding X dollars, or by imprisonment in the county jail for up to 1 year, or by imprisonment in the state prison for 16 months, 2 years, or 3 years, a sentencing triad that's common for felonies. But section 26230 doesn't have any language like this at all. So how do we know what the penalty is? I had to phone a friend and scour the beginning of the Penal Code to figure it out. I found Penal Code section 19.4, which says that when an act or omission is declared by a statute to be a public offense, and no penalty for the offense is prescribed in any statute, the act or omission is punishable as a misdemeanor. Okay, so that tells us it's a misdemeanor. Some misdemeanors are punishable by up to 90 days in county jail, and some are up to a year in county jail. So how do we know what applies here? We next turn to Penal Code section 19, which says except in cases where a different punishment is prescribed by any law of this state, every offense declared to be a misdemeanor is punishable by imprisonment in county jail not exceeding 6 months, or by a fine of not exceeding $1,000, or both. So there we have it. It drove me nuts for months, and this is what I do for a living. If someone with a California CCW license carries a gun in a restaurant that serves alcohol, or any other place that's prohibited by 26-230, they're facing a misdemeanor with exposure of up to 6 months in jail and or up to a $1,000 fine. Okay, so what's really likely to happen? I'm in court every day, mostly in Los Angeles County, so I'll draw on my experience to take a stab at the likely real-world consequences. We know that if you have a CCW license, you have a pretty clean record, right? You had to pass a background check just to get the license. So we should be able to put together a good mitigation packet and argue for a diversion. Diversion means that you complete some terms in exchange for dismissal of the case. No guilty plea, no finding of guilt, and no conviction. The court can grant diversion over the prosecutor's objection under Penal Code Section 1001.95. Terms of diversion for a case like this: I would expect a gun safety class, a fee of $100, maybe some community service in order to obey all laws. With that, the case should be dismissed in 3 to 6 months. Then we would file a petition to seal the arrest records, and for most purposes, you can answer that you were never even arrested or charged in the case. But there's the rub. I said for most purposes. Guess who's still going to see it? Your IA, the issuing agency that issued your CCW license, is still going to see that arrest, and they're very likely to revoke your license. And if the judge is unwilling to grant diversion for whatever reason, you're likely facing a year of summary probation with similar terms. Maybe community service, some small fines, a firearm safety class. And once that probation is up after 1 year, you'll be eligible for a dismissal of the case pursuant to Penal Code Section 1203.4. Many people call this an expungement. Your issuing agency is still going to see this, and they're going to revoke your license. Once the case is dismissed, how long the issuing agency will hold it against you before granting a new CCW application is really hard to say, and it likely varies a lot depending on the issuing agency. They will argue that your demonstrated unwillingness to follow the rules makes you reasonably likely to be a danger under Section 26202, Subdivision A, Subdivision 1. So many people will say, hey, thanks for the info, but I'd rather be tried by 12 than carried by 6. Or they'll say it's worth the risk for a misdemeanor. They calculate that their odds of getting caught are pretty small. After all, concealed is concealed, right? Well, I can't give that advice. As an attorney, I can't advise someone to violate the law. And the 2A community has fought hard to get to this point, where CCW licenses are much more widely available in California than they have been for decades. So not following the rules makes us all look bad. And losing that license we fought so hard to get would be really unfortunate. So please, follow the law, don't carry where you're not supposed to, and make us all look good. I'm Don Hammond at California Gun Law, and we'll catch you all next time. Stay informed, stay legal, stay safe.